About 9 out of 10 criminal cases in the U.S. are resolved by plea bargaining. Most criminal cases in the U.S. are resolved this way. Remember, prosecutors usually like to agree to a plea bargain because the courts are overloaded with cases, and plea bargaining is one way to settle cases quickly. It also gives them a conviction, which makes it look like they are doing a good job. And again, keep in mind that it is important to remember you do not have to accept the plea bargain that has been worked out. However, if you go to trial and are found guilty of your original charges, it is possible that you will receive a longer sentence. If you agree to accept a plea bargain, you give up some specific rights. These are the right to a trial, the right to testify in your own defense, and the right to argue against evidence. Some sample questions you should ask before accepting a plea bargain are: what charges am I pleading guilty to? How much time do I get? How much time have I already spent locked up? Are there programs I must attend? What are the rules of my probation/parole? What happens if you don't sign the form? Remember, you should completely understand the plea bargain before you knowingly sign the form. Let's take a look at some examples. Original charge: Maria was charged with burglary, felony C, facing up to 5 years in prison. The deal: the prosecutor offers a plea bargain. If Maria pleads guilty to theft, misdemeanor, the prosecutor will recommend a sentence of probation and restitution with no prison time. The result: Maria and her lawyer agree. She avoids the risk of a felony conviction and a long prison sentence. The prosecutor gets a conviction without a long trial. In court, appearance are very important. Dress your best. Wear your best clothes. Be neat and clean. Make sure you bathe and have your hair neat and combed. Be polite and quiet in court. Be seated when everyone else is, and rise only when asked to. Do not let your behavior disrupt the trial. Speak in a low voice to your attorney. Listen to what the witnesses for the prosecution are saying. If someone tells a lie about you, do not yell out or object. Lean over and tell your attorney, or write him or her a note about it, so he or she can handle it. Your lawyer is supposed to do all the talking for you. In most cases, when defendants speak out in court, what they say hurts their case instead of helping. If you must speak in court, talk to your lawyer first about what you want to say. The things that you positively do not want to do when going to court is: do not show up looking sloppy. Do not fail to appear. They can put a warrant out for your arrest if you fail to appear. Do not speak out of turn or interrupt. Do not yell out responses. Never raise your hand and ask if you can talk. Do not act like people do on court shows, like the one we see in television shows, as these people speak out of turn, interrupt, and talk back to the judge. In real life, these people could be sent to jail for how they act. And lastly, do not lie. If caught, you can be charged with perjury, which means more jail or prison time. It is better to say nothing than lie. And remember, if you do not act right in court, the judge will not find you fit to proceed, and you will spend more time at Hawaii State Hospital. Let's take a look at this scenario. During a witness testimony, Mark gets angry. He yells out, "That's a lie." The judge stops the trial, warns Mark that he will be held in contempt of court, and tells the jury to disregard his outburst. This makes Mark look bad. Instead of yelling out, let's take a look at this good example. Let's see, what did Susan do different? When a witness says something untrue, Susan stays calm and quietly whispers to her lawyer. Her lawyer then addresses it properly during cross-examination. This shows the judge she is respectful of the court process. Appropriate courtroom behavior is acting in a calm and appropriate manner. If you do not act appropriately in court, you could receive an additional charge. If you exhibit loud, demanding, and argumentative behavior in court, you can be charged with contempt of court. As a result of negative behavior, you can be physically removed from the courtroom, which could cause your hearing to be postponed, or your hearing could proceed without you. The penalty for being charged with contempt of court can be up to a year of jail time. In addition, you could be sent back to the hospital as incompetent to proceed, as one of the criteria for competency is ability to manifest appropriate courtroom behavior. Courtroom appearance is very important. So, can you tell me how you should dress to go to court? You do not have to answer out loud, but at least try to think of an answer in your mind. I will give you a couple seconds to think about this. So the answer is, whether or not you agree, first appearances are important. If you appear in court dirty, poorly dressed in old, raggedy clothing, you will not make a good impression. Therefore, it is important when you appear in court, you are clean, your hair is combed, your beard is shaved or groomed, and you wear your best clothes. You may even want to wear a tie and jacket if you have one. When talking in court, it is important to remember you cannot speak out in court, even if you hear something you do not agree with or you think is unfair. If you hear something said about you that is untrue, you should whisper quietly or write a note to your attorney. You may speak in court if you have been called to testify by your attorney, if your attorney and the state attorney are asking questions, or if the judge asks you a question. Remember, your attorney is your spokesperson, and he/she is representing your interests. One, not know who will be in the courtroom. You should know who will be in the courtroom for your trial. The most important people are: judge. The judge decides guilt or innocence when there is no jury. The judge passes sentence if there is a verdict of guilty. The judge sets the defendant free if there is a verdict of not guilty. Jury. The jury is impartial, meaning they are not supposed to be on anyone's side during the trial. They are supposed to weigh all the evidence and then make a fair decision. Prosecutor. The prosecuting attorney can also be referred to as the state attorney. They represent the state's case against you. Their job is to prove you guilty. They are not on your side. Defense attorney. The defense attorney is the lawyer who is on your side in the trial. They are trying to protect you, and their goal is to get you free, or if you are found guilty, get a reduced sentence. Two, work with your lawyer. You need to be able to work with your lawyer. Your lawyer is trying to help you. He or she has gone to school to study law and is familiar with what goes on in the courtroom. It is your best interest to cooperate with your lawyer in defending yourself against the criminal charges against you. 3. You need to know what is happening in the courtroom. If something happens that you do not understand, you should ask your lawyer to explain it to you. You can do this by writing your lawyer a note or whispering to him or her. If you have trouble understanding your lawyer, say so and ask your lawyer again. 4. You must pay attention in the courtroom and listen to what the judge, prosecutor, your lawyer, and the witness have to say. If you feel that someone is not telling, you should quietly tell your lawyer or write him or her a note. Your lawyer will then handle the situation. It is important to remember that your lawyer speaks for you in the courtroom. 5. In the courtroom, you must always remain silent unless the judge, prosecutor, or your lawyer asks you a question. You may quietly tell your lawyer something or write a note when need to, but do not disrupt the court to do so. If you speak out of turn, you may be held in contempt of court. This is a serious charge, so do not talk to the court unless you are asked to do so. Usually when people speak out of turn in court, what they say hurts their case rather than helping it. 6. When you go to court, it is important to dress neatly in clean, conservative, and nice clothes. Wear your best clothes. You want to look like you made a special effort to look good in court. Remember, the judge and jury may have a better opinion of someone who is neat and clean than they would of someone who is dirty and has not taken care of his or her grooming or clothes. 7. If you are asked to testify, pay attention to the questions. Listen carefully and answer the questions as well as you can. If you do not understand the questions, ask the attorney to repeat the questions. Answer only the question. Do not talking about something they have not asked you. For example, if you are asked your name, simply reply with your name, then stop and wait for the next question. Do not say anything unless you ask to do so. 8. You need to know the different kinds of pleas that you can enter. You should determine which plea to use by talking to your lawyer and working out the plea with the lawyer. There are 4 different ways to plead, and it is not guilty, guilty, no contest, and not guilty by reason of insanity. 9. You need to know what your charges are and whether the charges are misdemeanors or felonies. Also, you need to know what you had to do to get charged with the crime you are accused of committing. This will help you and your lawyer make an informed plea. 10. You will need to describe everything you think happened to your lawyer. You need to be able to explain to your lawyer what happened just before you were arrested and why the police arrested you. Your lawyer needs to know this so you can be defended in court. And 11. You need to know what will happen to you if you are found guilty of the charges. Depending on your charge and how serious it is, one of 3 things could happen to you: jail or prison. You could be sent to jail or prison. How long you spend depends on the seriousness of your charge. The more serious the charge, the longer your sentence could be. Probation. You might receive probation. The court has jurisdiction over you. You are serving your sentence in the community rather than jail. You will have a probation officer who you will see on a regular basis, such as once a month, and you would have to follow your terms of your probation. Some people on probation have to go to a mental health center regularly. If you do not follow the terms of your probation, the judge can order you to. Treatment. You could be found not guilty by reason of insanity. You will likely sent back to Hawaii State Hospital for treatment. You will stay at the hospital until such a time that the judge feels you are safe to return to the community. Fine. A fine is money that goes to the court. Restitution. If your crime involved damages to another, you can be sentenced to pay restitution. Restitution is money that goes to the victim. So, in summary, the key takeaways to be found fit to proceed: know your charges, know the pleas, know the possible sentences, know the roles of the court personnel, understand the court process, be realistic about the court process, be motivated to help your own defense, be able to make sound decisions, be able to work with your attorney, be able to give a consistent account of events, be able to handle the stress of a trial, be able to testify if needed. So in summary, we talked about the different types of pleas that you can do, how important it is to take your medications when prescribed, how appearance and behavior matter in court, how to be fit to proceed, the types of crimes, and the key players of the court, like the judge and lawyer. So in summary, we talked about the different types of pleas that you can do, how important it is to take your medications when prescribed, how appearance and behavior matter in court, how to be fit to proceed, the types of crimes, and the key players of the court, like the judge and lawyer.
Your charges, know the pleas, know the possible sentences, know the roles of the court personnel, understand the court process, be motivated to help your own defense, be able to defense, be able to make sound decisions, be able to work with your attorney, be able to